Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Today we'll be discussing the backlog of cases in the Crown Court and how to reduce it. Rob Allen, my co-host, is here, as are two criminal barristers, Alex Chalk, also former Lord Chancellor, and Dominic Thomas. Rob, you've recently done jury service. What perspective did that give you on this queue of cases waiting to get into the Crown Court?
Well, it was a bit puzzling, really, having been told to be available for 2 weeks. After 2.5 days, I was sent home. All the cases that I was down to hear seemed to have collapsed for one reason or another.
You literally didn't go into the courtroom at all?
I didn't get into a courtroom. Me and 16 others were in a waiting area. We were told there were legal complications in one case, not further explained. One defendant didn't turn up. And in the third, the defendant decided to plead guilty at the last minute, so that didn't go ahead. And rather than keep us there, they said, not only can you go home, but your jury service is now completed. So a bit frustrating.
Alex, we are talking here about this Crown Court backlog of cases. How long is it and why has it got so long?
Well, it's huge. So to give some kind of context, in 2010, it was around about 48,000 in the Crown Court.
48,000 cases were waiting to happen.
Correct. 48,000 cases waiting to come on. Then just prior to the pandemic, so 2019, that had dropped to around 39,000. Then, as a result of the pandemic, that figure then ticked up to about 55,000. It was hoped, when I was in office, we were going to bend the curve and it was going to start to come down. But in fact, it's gone up remorselessly. And the figure now is over 70,000. You know, a figure in and of itself without any context is meaningless. But the point is that means rape cases not getting listed for trial for potentially 2 years or more. And victims not getting justice. And yes, defendants not finding out what their future is. I went along to Wandsworth Prison, right? I was the Secretary of State for Justice, and I spoke to two guys in a cell. One guy who'd been there on remand, never been in custody before, and he'd been in custody for 8 months. Now, as you will know, in fact, the custody time limit should be 6 months. In other words, the prosecution have got to get this case on within a reasonable period of time, but his custody time limit had been extended. This is somebody who is not convicted of anything. He could be acquitted. Right? But then also, if you are the alleged victim of a rape and you have suffered the trauma and the horror, not just of the incident, but waiting for this trial, to be told by the judge, your case isn't going to be held until 2027, that is unbelievably upsetting. So every which way you go, whether it's justice for victims, whether it's a fair process for defendants, or whether it's justice for the taxpayers, delay is a disaster.
And in terms of victims, does it mean that some just don't stay the course?
Well, this is exactly one of the things we work really hard to do is to tick up the number of rape prosecutions, and now they're significantly higher than in 2010. But although we charge a lot, guess what? Victims drop out of the process at an unacceptable rate. And that is in large part because of the delays. So this is completely unconscionable. It's unconscionable for the rule of law apart from anything else. And that's why, in the time-honoured expression, something must be done.
And Dominic, could you give us an example perhaps of a case which has had very long delays and what the impact has been on all those involved?
Well, a defendant I represent has had a case listed for trial 18 months hence. He was accused of rape. We get to the trial date. There was no court available to hear his case, a rape case. It's gone off for another 18 months. He's now depressive, alcoholic, suicidal. Everybody who is involved in these cases, the alleged victims, the defendants, are living in limbo. They can't restart their life until they've got on the other side of these cases. So it's a horrific situation for everyone involved. And that is not an outlier. That is absolutely typical of the situation in Crown Courts up and down the country.
Yeah, I did a murder earlier this year. It was actually started at the end of last year. There's a appalling case, 15-year-old girl who'd been hacked down in Croydon, just outside the Whitgift Centre. And there was some suggestion that the case was going to be adjourned again. I cannot tell you how upsetting that was for the parents of the victim. So to have to go into that witness waiting room and to speak to them and to say that the judge is considering whether to adjourn this case, I mean, the colour drained from their cheeks, the tears. Delay is unbelievably distressing.
And what about, Alex, the actual impact of delays on the trial when your date comes up?
There is no doubt, and by the way, I'm not making a criticism of the defence here, but of course it's a great point for them in a number of cases. Well, members of the jury, can you really be sure what happened on that occasion? It was a long time ago now, memories fade. You have to be satisfied so that you are sure nothing less than that will do, and so on. And that's a perfectly proper point for the defence to make. They're doing their job. Totally get that. But as a prosecutor, it's a nightmare. It's not good for anyone. And the poor old jury as well are sitting there thinking, the judge has told us we've got to be sure about precisely what happened. I know I'm fallible. How on earth am I supposed to decide guilt or innocence in this case?
Well, a much more brutal example even than that I can think of. In a case involving fraudsters seeking to gull the elderly, case took so long to get on that fully a third of the alleged victims had simply died by the time the trial came on.
And, I mean, have you seen this issue that because the delays are so long, people's memory of what happened in the incident has faded?
Oh, yes. And Alex makes the point that it's a friend to the defence. I don't think it's a friend to justice either way you look at it, because, of course, if an alleged victim makes mistakes, trips up in their evidence, point will be made, well, it's a long time ago, perhaps they're not remembering it correctly, and the judge might invite the jury to be more sympathetic about the alleged victim account. So what we want is those participants in a trial to replay what they say happened with events as fresh as possible in their minds. And I think from both sides we recognise that people are struggling.
What about, Dominic, this narrative that defendants are pleading not guilty, going for trial in the hope that the alleged victim concerned is just going to get so fed up with waiting that they're going to withdraw from the whole process?
I think it would be idle to suggest that that never happens, but I think it's pretty rare. It's certainly, I think, very rare in circumstances where the defendant is locked up, because in our system those cases are still brought on much quicker than where the defendant is on bail. More common, I think, is the circumstance where a defendant is on tag. They've got an electronic monitor around their ankle, and whilst they're on that electronic tag, they are building up half day. So every day that they're on the tag is half a day custody served if they're ever sentenced. And that's obviously a much more congenial way to try and serve some of your sentence. So I think it undoubtedly is true that in cases where a defendant is on bail and has the tag, there is a disincentive to plead guilty early, because you are racking up half days whilst you're waiting for your trial. And in the current circumstances of extremely long delays, it's not, in smaller cases, uncommon for a defendant to plead guilty late, and when it comes to sentence, he or she has served nearly all of the sentence on tag.
There is anecdotal evidence, so just take this obviously with a pinch of salt, but people applying to the court to be put on a qualifying tag, right? So there might be people who have bail conditions not to go to Watford High Street or whatever, but they might be saying, Judge, well, would you mind terribly putting me on a qualifying curfew? Because that means that it's an insurance policy, in effect, against them getting convicted, because very often there'll be time served on the basis that Dominic's helpfully set out.
I'd do it. It seems sensible.
And our prisons are over full, so anything that is helping the system...
Of course, I'm making a separate point, which is that we shouldn't be punishing people in the pre-trial process. As a matter of principle, the whole point of pre-trial bail conditions is to avoid them committing further offences whilst on bail, failing to surrender, etc. What we shouldn't be doing is saying, well, because we've got these huge delays, we better just sort of punish everyone, because you'll be catching people who turn out to be completely innocent.
Well, we've heard about quite a lot of problems so far. The government has turned to Lord Justice Leveson, retired very senior judge, to do a review of the efficiency of the criminal courts. Alex, what will he be looking at?
Well, let me just say, the government's doing exactly the right thing. Okay, so this is very sensible to get Lord Justice Leveson to do this. My quibble is they should have done it sooner. So I would have done this on the 5th of July. I wouldn't have waited this time. And I think part of the problem is by doing the David Gauke thing first, namely, please can we have a review of all the sentences to see if they're calibrated at the right level. Although it's worthwhile, it is the cart before the horse, because any dividend in terms of prison population pressure easing that you get from that will be many years hence. But sorting out this business of making the courts more efficient, the yield on that is far more immediate because you get cases going through the system. If cases go through the system, fewer people are in pre-trial detention. So, to your question, what's he actually going to be looking at? He's going to be looking at what is the right threshold at which cases can be heard in the Crown Court. We all love juries, certainly I do. I will yield to no one in my adoration of the jury system, very important. But about 90% of all cases are in the Magistrates' Court at the moment. Should it be 92%? Should it be 93%? Plainly, you've got to move that threshold. If you don't move that threshold,
Hold it there, Alex,
we are
before
doomed
we get
to
into
failure.
That. Dominic, do we need a review of efficiency of the criminal courts?
Just taking back a step, first question we've got to ask ourselves is, does Leveson have a warrant to say that the system is simply underfunded? Or is he being asked to carry out his investigations on the condition that he doesn't say that, if that's the truth? Because the answer to that is that the system is catastrophically underfunded. Those listening might be surprised to hear that on any given day, our court buildings are generally 20, 25, 30% empty. And the reason they're not being used is because there is a cap on the number of judge hours in any given year that the government is prepared to pay for. The cap at the moment is about 108,000 days of judicial sitting. We could probably double that with the pool of available judicial talent that we have out there. And so it's a completely artificial figure that the government sets for reasons of money. If Sir Brian Leveson's job was being conducted entirely without him being told there's no more money, his first and most straightforward answer would be this: we've got to lift the cap. It's an emergency. And in this situation, we've got to throw all the judges at the problem that we can. It's unimaginable that we have a backlog like we do, and 30% of our courtrooms on any given day are just empty.
We'll have to wait and see how Leveson interprets his terms of reference, whether he goes down that financial route. I mean, Alex, you've championed this idea of getting relatively minor cases out of the Crown Court where possible. What kinds of cases have you in mind, and why shouldn't the people have the opportunity to have justice in the Crown Court?
I'll try and be as brief as possible. But first of all, it's very important. What I'm proposing is not misrepresented as an attack on jury. Jury's system is a lamp of our liberty, etc. I absolutely think we should have it for murder trials, we should have it for rape cases, for arson with intent, for terrorism cases, manslaughter, no question, right? However, it is an extremely resource-intensive thing to do. And I think your listeners may ask themselves the question, is it right that somebody who is in possession of a wrap of cannabis can elect a Crown Court trial, which might take 3, 4, 5 days in front of judge and jury, when the penalty may be just a fine or a community order? Or somebody who's being arrested for being drunk and disorderly, and there is an assault with intent to resist arrest. By the way, not one that causes even as much as the reddening of the skin. I'm simply suggesting that to ensure that those rape victims can get their case heard on in a reasonable period of time, is it right that the Crown Court should be clogged up with cases which are, in the grand scheme of things, relatively minor?
Can I just deal with a couple of misapprehensions, I think, in what Alex has just said? First of all, to judge the seriousness of the case by the punishment that a defendant in the case might receive misses quite a lot of the story. Someone who assaulted a police officer in the course of being arrested, well, it may well be that the punishment for that is quite modest in court. But what about your employment prospects with something like that on your record? It's simply untrue to suggest that for the people involved in cases, there are really any small cases. I represented once a lady who was charged with making really quite minor threats in her cul-de-sac against the local children. We had a trial in front of a jury. At that pace, with that degree of scrutiny, which you only get in front of a jury, perhaps the eighth witness broke down and said the parents didn't like this woman, she was slightly eccentric, and they'd ganged up on her, they'd made it up. And that was exposed in front of a jury. I'm not at all sure it would have been exposed at the pace and in the setting that you would get in a judge-alone trial. 1 month after she was acquitted, my solicitor sent me a letter that she'd written. All I was waiting for in my life was to clear my name, acquit myself. She'd killed herself. Now, in terms of the sentence, that's a small trial, but it does tell the story of what a large thing it is in a person's life.
That is a powerful example. And powerfully though it has been put, that is something that could be said of all cases, including those where they have to be heard in the magistrate's court. If you or I were accused of common assault, that has to be heard in the magistrate's court. Now, of course, that is completely life-altering. If I'm convicted, I'm disbarred, I can't work again, reputation destroyed, perhaps family. It is, with respect, no answer to the problem to say, yes, but there are some cases which, if you made them summary only, would be life-changing. That has always been the case. And the one thing that I wouldn't accept is that you can't have a searching inquiry in front of the magistrate court. You can. And the other thing to bear in mind is for that poor police officer who is the victim, the number I have spoken to, including who've come to Parliament and said, I've got to wait 2 years to get justice in this case, that then becomes a nonsense because of the old maxim that justice delayed is justice denied.
So to deal with this, Alex, you were proposing this idea of an intermediate court. I mean, is that just extending the magistrates so they'll deal with more cases?
What in effect I'm proposing is this, and I should be clear, there's more than one way to sort this, but here's one proposal, that what you would say is for those so-called triable either way offences, in other words, those that can be heard in the magistrate's court if the defendant agrees to it and the magistrates say, right, we're accepting jurisdiction because it's not that serious, or he or she can elect for it to be in the Crown Court. So he says, right, the circumstances were it was a Saturday night in Cheltenham High Street. A police officer came along, told me to quieten down a bit. I told him where to go, and then I spat at him. And the police officer arrested him, and then there was a bit of argy-bargy, and he scraped him or something. Right. The magistrates could say, we're going to hear this in the magistrate's court because we think that our sentencing powers are enough. He says, no, I'm going upstairs. I'm going to the Crown Court. I want judge and jury. Fine. The judge, under my proposal, would say, let's have a little look at this. Okay, the maximum sentence, assault with intent to resist arrest, is 2 years. So this is a lower level assault. Nasty, but low level. Right. I, the judge, will make a decision that, yes, you'll still be in the Crown Court, but it's going to be an intermediate version of the Crown Court, which means that your tribunal won't be judge and jury. It'll be a judge and 2 wingers, which is a slang way of saying 2 magistrates that sit with you. They will decide it. Now, that is already a court composition that we're familiar with, because somebody who appeals from the magistrate's court would be tried by precisely that tribunal. So the idea is that case, which would normally have taken 5 days or so, or 3 days or 4 days, will be dealt with more likely in 1 or 2 days, which means that those more serious cases now don't have to compete with all these other lower level offences in the system.
So this panel of a judge and 2 magistrates, they would decide on guilt or innocence.
They would.
And they would decide on sentence if conviction.
Well, in fact, it would be the judge who decides on the sentence bit of it, because that's the legal side of it. But yes, you're absolutely right. And just to emphasise the point, at the moment, over 90% of cases is 3 magistrates in the normal way. If you appeal from the magistrate's court and you get a rehearing, you already have a judge and 2 magistrates. All I'm saying, which I think is a recalibration, this is evolution, not revolution, is to simply say for those lower level cases, it would be tried by that existing and well understood constitution.
Several problems with that immediately. The first is that you're taking precisely the judges and the judicial sitting hours that we're short of away from the Crown Court, and therefore you're also spending a lot of money on retraining and new procedure. But the second problem is one I predict. Inevitably, to make it seem more attractive and more modest, the list of cases which are proposed would be dealt with by this intermediate court is quite small at the moment. Of course, what's going to happen as night follows day is mission creep. So as resources come under increasing pressure, the temptation for succeeding governments to just add here and there to the list of offences that will be dealt with by the intermediate courts will be almost overwhelming. And where you start with minor assaults against police officers, as Alex has just described, in 3 years' time we'll have, well, you can have minor sex offences dealt with by the intermediate court. And governments will like that because there is already a sense abroad in government that they're not happy with the conviction rate on sex cases, for instance. So why not put as many of them as possible in front of an employee of the state?
That's not true.
There will be an institutional pressure to deal with these cases quickly, cheaply. There will be an institutional pressure to deal with cases in a way that are more victim-friendly in sex cases, or to take another category of cases that are likely to be dealt with by the intermediate courts. Protest cases. Do we really want protest cases to be dealt with by an employee of the state, or do we want important issues of that kind to be dealt with by our peers, by a jury? I predict it now, if these intermediate courts come in, succeeding administrations, succeeding governments will add to the list.
Can I deal with some of these points? First of all, with no disrespect, I think it is really troubling to label judges employees of the state. They're not. And to call them employees of the state, I think, is not just to diminish, but is to seriously mischaracterize them, point one. Point two, the suggestion that the state is sitting there saying, oh, yes, the conviction rate for rape is too low. That's not the case. I was the state for 2 years. We never once had a conversation where we sat there and said, actually, we want to engineer this in that way. The third point is the idea that there's going to be some massive mission creep is an attractive argument, but it's one that doesn't stand up to scrutiny. If you were going to loop in all those cases, you wouldn't just be taking a few cases out of the Crown Court, you'd be taking their bread and butter. But the absolute, I think, killer argument, with respect, is that what I understand Dominic to be saying is basically, don't worry, folks, a few more sitting days, it'll all be sorted. I can tell you this, as God is my witness, that is no answer. Even if you were to increase sitting days, and I absolutely agree, max them out. That's what the MOJ should be doing. Make it 110, make it 115,000. That will not bend the curve. We can sit here and we can clutch our pearls and we can say, you know, we've got our concerns about X, Y, and Z and the precise limit, etc. But if we do nothing, the situation is irrecoverable. Something has got to be done, and simply saying more sitting days is no answer to the scale of the problem.
Can I just say, to talk about a slippery slope, you know, what you're proposing is that people who are facing imprisonment of over a year, which is quite a long time, actually, shouldn't be judged by their peers. And we've already had a situation where previously they could be judged by their peers if the offence that they're accused of would have got a sentence of over 6 months. And we've had that increased to a year. So magistrates can now sentence someone for one offence to up to a year. So that's already slipped in terms of people's right to a jury. And a sentence of imprisonment of over a year is quite a long time.
Yeah. No, look, I absolutely understand that, which is why we're in the business of weighing things up. But those who say, do you know what, this is a monstrous infringement on the rights of the individual and so on, have got to work up what they are going to say to that victim of rape, to the parents of that child who's been murdered, and yes, what they are going to say in that cell in Wandsworth Prison to that person who is accused, who is not guilty of any crime, who is sitting there in that prison where he's been, you know, on 23 hours a day lockup for 8 months because his trial hasn't been called on. The reality is, looking purely at the length of the punishment is of course important, but it is not the only issue. We have got to make sure that overall we have a justice system worthy of the name. The way I've put it is, yes, the jury system is a Rolls-Royce system, but at the moment we have so many Rolls-Royces on the road that it's not a Rolls-Royce experience, if you see what I mean, because there is too much traffic. So whilst I absolutely understand the misgivings that some people might have, you have to weigh that against the fact that at the moment it's not working for anyone.
The jury system, I'm really worried, it's not a Rolls-Royce. The jury system is a Toyota. The jury system is the democratic system. Alex asked what I would say to victim of rape, what I would say to a defendant who's waiting too long to get his trial on, what I would say to the family of a murder victim. Well, I'll tell him. I'll say what I do already say to all of those participants in criminal proceedings, which is your government doesn't care to fund the system as it should.
So is more funding your kind of only answer to reducing the backlog, or have you got any other ideas?
It's not, but funding must come in order to release the judges who are actually the only solution to the problem. If you want a significant change in the problem, that is the only one. The sort of tinkering that Alex is describing with intermediate courts won't solve the problem.
But why do you say it won't?
Because it won't deal with enough cases.
But how do you know that?
But in answer to your question, Rob, what else might be done to try and address the problem of the backlog? Well, there's two suggestions I'd make straight off the bat. First of all, we waste thousands of hours in our current Crown Court system waiting for defendants to turn up from prison.
These are people coming from prison in a van.
In a van.
Or, in fact, from police custody, I believe, as well.
Yes, and I did a 5-month murder at the Old Bailey, which was only a 5-month murder because of this problem. Had the defendants been brought to court on time, it might well have been 2 months, 3 months. The problem was that bad. We were wasting half days, 2/3 of the day. And clearly the providers of this transport must think that there is no financial penalty in the contracts they have signed to operate in this way. And another thing that will take pressure off the entire system is what's called in the trade diversion. There are a lot of cases coming to court that are just ridiculous cases that should never be in court. I'll give you an example. I represented a man who had an argument with his neighbour, parking, whether he had slightly overlapped his neighbour's parking space. There were no lines on the road. It was just the parking space in their minds. They have a row. One of them pushes the other. Now, admittedly, that was in the magistrate's court, but we see cases of that kind of nonsense being taken to the Crown Court. Shouldn't be in any court. There should be some sort of provision for apology, for caution. And very experienced solicitors and barristers, if you follow legal social media, are saying this all over the shop.
So that is all relevant, of course, but it's at the margin. The fact is, as a matter of statistics, not just anecdote, there is a lot more rape in the Crown Court list at the moment, okay? Because a huge number of agencies, whether it's the CPS, whether it's the police, have been investigating and charging rape. So you've got this double whammy. Not only are there more cases in the case mix, they are more complex cases. In very simple terms, the guilty plea rate for sex offences is lower because people don't want to admit that they're rapists.
And some aren't.
And some aren't, exactly. And some will say, look, they're not, I want to have a trial. And that's absolutely fine and entirely as it should be. But my central point is this. Of course, Dominic's absolutely right that people are being produced late. That's got to be solved. It's also, I dare say, true that from time to time people are being charged who probably ought not in the cold light of day to be charged. However, even if you were to get everyone at court absolutely on time, even if you were to make sure that no daft cases ever got charged, even if you were to ensure that you put £2 billion into the system tomorrow, you would not get rid of the backlog. There has to be, in my view, a more evidence-based argument, because we can all sit here and pick holes in the system, but unless fixing those holes is going to solve the big problem, then it's just commentary. It's not a solution.
Can I float something that I think could resolve this to some extent without an intermediate court, which is to take a whole raft of offences where the maximum sentence at the moment is 2 years and simply bring those down to a year, which means that they could be dealt with in the magistrate's court. And from the defendant's point of view, they're faced with a maximum sentence which is much lower than it used to be. So what about that? Further kind of shouting at the policeman, why not bring that sentence down to a year?
It's a great suggestion, but that in and of itself probably wouldn't do enough to move the dial. That would certainly apply in respect of assault with intent to resist arrest. However, those cases that you would need to be getting tried by my intermediate court would actually have to be cases where the maximum sentence is a lot longer. You would have to take cases which are currently sentenced at around 5 years, say, ABH, and say, well, that will just be 1 year. And I just don't think that the public will stomach that. And I think quite rightly they won't, because, ABH can be a really upsetting, unpleasant crime. And so we have to make sure that when we're considering this, to remember public confidence. And one of the reasons why I'm sort of reasonably exercised about all this is I see that we are at a critical moment, potentially, for addressing this public confidence issue. If people do not think they can get justice within a reasonable period of time, then I think there's a danger that increasingly more and more people will disengage, and that's corrosive.
I think we all agree with that. Dominic, what about bringing down that sentence from maximum 2 years to 1 year?
Listen, I'm a jury fundamentalist, and if there was an infinite money tree, I'd have every case decided by a jury. There has to be a line somewhere. About that, I agree with Alex. Now, of course, if society as a whole decides that certain offences need not receive longer than a 1 year sentence, then they are properly tried by the magistrates. So I'd have much less difficulty with that than the introduction of intermediate courts, because that's bringing everything down. Hopefully, one product of the Gork review will be precisely as you suggest, to try and release us from the clutches of this addiction of sending people to prison and for increasingly longer times.
A fascinating discussion. Thank you both. We need to draw it to a close, and we do it by asking each of you one thing you do to improve the system. So if you were in Lord Leveson's shoes, what would be your top recommendation to reduce the delays in the Crown Court? I think we might already have heard it, Dominic, but tell us again.
No empty courtrooms. Put judges in those courtrooms, pay the judges to hear trials. It is outrageous that our courts should sometimes stand 30% empty, and we are not going to solve this epidemic of delay unless we first solve that issue.
My one top thing is this intermediate court's got to happen. Without it, we are doomed to ever deteriorating service standards. It's got to be done, and it's got to be done quickly.
OK. Penelope, what would you do?
Well, going back to the idea of reducing sentencing, my solution is to get cases out of the Crown Court which are relatively minor, but in a different way, as in reducing the sentence involved for them. And I concede that there might be some problems along the way in implementing that. Rob?
Well, I was taken with Dominic's point about diversion, really, and I accept it may not produce enough, but I do think it's an area that really needs looking at. I hope Leveson does. I hope he looks at problem solving, restorative justice, these kinds of things that can reduce the need for things to get into the courts at all.
Thanks, Rob, Alex and Dominic. And go to our programme notes for more information about Lord Leveson's review of courts and about our two guests. And if you like our podcast, do subscribe. Bye.
Bye.
Bye-bye.
Bye.